Okay. Yep.
Shelter petition order.
Thank you.
See? See it there? Shouldn't be. You have to do. If you look at that monitor there, you can see the kids. You're not supposed to. The juvenile's not working. Even though
Okay, we're going with,
Your Honor, I need to speak to her first.
all right.
Give me 5 minutes, okay, please?
mute the speaker. Hit this button. You want to mute this?
Have you seen the movie The Monsters?
No, I haven't.
There's a scene where they're trying to break into the roof stamping board, so they're timing it as soon as he stamps, they smash the floor. So when you were stapling, I think he was hitting the thing at the same
Oh,
time. So
oh, that's so funny.
So the photos are stapled. So you need to watch that.
I do.
Right.
Okay. Got Farron Combs. How old are you, young man?
14. 14.
14? Where do you go to school?
Silver Lakes Middle School.
What grade are you in?
8th.
What's your grade point average? So it's not good. Because I know it's,
Average is a 2.8. He also has an IEP plan as well, so according to his IEP plan, he's actually doing academically well, better than he was before.
well, ma'am, I'm not saying that he's not capable or not. I'm just saying he could be doing better. And he certainly didn't have, if this occurred, he didn't have his head in the right direction. Okay, now, what's the recommendation?
One judge, he stands to be engaged home detention outright in court.
Released to his parents? All right, young man, releasing you to your parents. You have to go to school every day, be in class, be on time. Okay, and make sure you appear in court. Have a good day. Thank you, ma'am. Capers, Miss Capers? Lakia? Stand up. Okay. You have an out-of-county hold out of Osceola County or Pasco County, I'm not sure. Could be both.
Judge, I have someone here for her.
Okay. Who are you, ma'am?
I'm Suzette St. Remy, her dependency case manager.
Okay. And I've got out-of-county holds out of Osceola and out of Pasco.
Yes.
Okay, what are you recommending we do?
Well, I'm on the dependency side, so she could be transferred to Circuit 9 since she has Osceola and Orange.
Okay. What are you recommending? What's that?
Transfer back to Osceola County.
Okay. Transmitted to Osceola County.
Your Honor, am I allowed to speak to her in the back by any chance?
Yes, ma'am.
Thank you.
Jason Pierre. How old are you, Mr. Pierre? What's your recommendation on Mr. Pierre? Court finds probable cause on the grand theft.
What was the last name? I'm sorry. Pierre.
If you score 17 points, the fund will be at
Mr. Pierre is not, I thought that was Mr. Pierre there. That's him. Okay. All right, scored 17 points, so what's the recommendation? Secure detention? 21 days?
not allowed to say how many days.
Seem to move up the scale, Mr. Pierre. Mr. Pierre, you with me? You want to go with them? Well, I guess we could just send you with them. All right. They're recommending 21 days. All right, 21 days. Have a good day. Now we're here with Adonis Araya. Excuse me?
Did you score 20 points? The department recommended secure detention.
I imagine. How old are you, Mr. Araya? Yeah, well, you're 17, you're looking to make prison. Yeah, 'cause on burglary armed, they'll direct file on you a lot of times. Court finds probable cause, secure detention, 21 days. And then we got Daniel Rodriguez.
Judge, you scored 18 points. If you absconded, the department will be recommending secure detention.
This is a pickup order, correct?
That's correct, Judge.
She's gonna need the interpreter, Judge.
Okay.
Good morning, Your Honor. Spanish
Good morning. Swear to interpret from English to Spanish and Spanish to English as best you can.
I will, Your Honor.
Thank you very much.
Easy, certified Spanish.
And we have Daniel Rodriguez. There's a
Daniel
pickup
Rodriguez,
order.
Lo van a recoger, lo van a llevar a la
He
detención.
scores 18 points. You want him for secure detention?
18 puntos, así que le van a dar, lo van a mantener en el centro de detención por 21 días.
Ma'am,
Señora,
the judge has ordered, who's handling his case, that
el juez
he
está
be
ordenando
held
por
in
su caso
secure
que lo
detention.
mantengan en un centro de detención asegurado.
Okay, he'll be detained for 21
Lo van a
days
tener allí por 21 días.
at the Broward County Juvenile Facility,
en el,
but he will be brought before the court to whom the case is
Y
assigned.
de ahí lo llevarán al juez que le hayan asignado para su caso.
Thank you.
Gracias. Señora. Espere afuera.
Okay, we ready? Ready in the main jail?
No contact.
Yeah, Judge.
Okay, we have Yania Kolakova.
Yeah, no problem, Your Honor. No problem. Good morning.
Okay. You've got a violation of pretrial release, $1,000 bond, no contact with the alleged victim.
That's it?
Let's go, people, please.
That's it? $10,000 bond, $100? Yeah. Oh, my God.
Stephanie Nawakoa.
Good try. Good morning, Your Honor. Scott Song on behalf of Stephanie Monaco. Also present are my client's father, mother, and sister. Scott Saul before the court. Judge, you have a violation of probation warrant as well as a new allegation of an injunction. Is there any bond amount affixed to the violation of probation warrant?
No, there's a no bond hold. Counsel on the violation of probation to Judge McHugh. I'm gonna set bond, okay. Are these the people who got the restraining order?
No.
No, okay. I'm setting bond in the amount of $1,000 on count one. Okay, but, and no contact with the alleged victim. You're gonna have to go before Judge McHugh. She's set for hearing on 12/4 at 8:30 a.m. But maybe you can get it moved up, counsel, I don't know.
Do we have the power here to have it print for Monday, or I'm going to have to do that?
No, I
with
do
Judge
not.
McHugh?
I have no ability to do any scheduling.
Okay, all right. I'll
But I
address that.
appreciate it, counsel. Thank you very much. Donna Thompson.
affirmed.
Donna Thompson, you're charged with domestic battery. I find probable cause. Bond is set the amount of $500. No contact with the alleged victim.
$50, 52, 500.
Have a good day, ma'am. Martinez Peraza.
All right.
And I need a Spanish translator, please.
Latina, you're Latina Peraza, you're charged.
I need a Spanish
with-
translator.
Oh,
Your Honor,
domestic,
so-
yep. You're charged with domestic battery. I find probable cause, bond is set in the amount of $500. No contact with the alleged victim.
Señora, a usted la acusan de agresión física en violencia intrafamiliar, le imponen una fianza de $500 y no debe tener contacto o comunicación con la víctima.
Okay, thank you.
Gracias.
Then we have Candy Covington. Candy Covington, you're charged with aggravated battery. Bond is set in the amount of $1,500. Aggravated battery on a person over the age of 65. Bond is set in the amount of $1,500. Aggravated assault with attempt to commit a felony, $1,000 bond. Battery on a person over the age of 65, $1,000 bond. There'll be no contact with the alleged victim. And,
Judge, did you find probable cause as to each of the counts?
yeah, court finds probable cause. All counts.
And Jesselyn will be on behalf of the state.
Fernando Respaldo Vasquez. You're charged with domestic battery. I find probable cause, bond is set in the amount of $500 on count one, criminal mischief, $100 bond, and resisting, $100 bond. No contact with the alleged victim, probable cause, all counts. And Cornelius Bembry. Cornelius Bembry, charged with domestic battery. I find probable cause, bond set in the amount of $500. No contact with the alleged victim. Philip Owsley.
He refused to attend, Your Honor.
He what?
He refused to attend.
Refused to appear. Reset. Then we have Ezra Serrano. Mr. Serrano, you're charged with domestic battery. Bond is set in the amount of $1,000. No contact with the alleged victim. No firearms, and all firearms to be surrendered within 24 hours of your release.
What's that? Attorney here at the end of the docket, you want to know when you get a chance, if you could call earlier, it's on page 20. So it's probably at the end of
Okay,
that.
yeah, I'll try to get to it. Okay, Rafi Rishamari. Okay. Who are you, sir?
James Jones from Adamville, on behalf of the wife or girlfriend.
Okay. You're charged, sir, with 2 counts of domestic violence. I find probable cause. Bond is set in the amount of $500 each count. No contact and no alcohol.
Thank you. Thank you, Judge.
Thank you. Anderson Montegro.
He was released, Judge.
Where is he?
No, he's released. He's released from custody.
I'm sorry, I'm not hearing you. He's not here. Okay. Raymond Qualalo, Quallo.
Yes, Judge.
Okay, you're charged with battery. I find probable cause, $500 bond, no contact with the alleged victim. Daryl Tony. You're charged with aggravated assault with a deadly weapon, domestic violence, $3,500 bond, battery, domestic violence, $1,000 bond, and then you have a violation of probation, no bond hold. There'll be no contact with the alleged victim. If you are released, all firearms must be surrendered within 24 hours. And you will go before the judge on a violation of probation on 12/24.
Judge, probable cause on both counts?
12-4, Judge.
What's that?
Probable cause found on both counts?
Yeah, found
Okay.
probable cause,
Okay,
right.
thank you.
Judge, it said 12-4 on my note.
I've got it as the 4th.
The 4th, yes. Thank you, sir.
Who's that I just called? Tony, okay.
Taking one out of turn. Kenneth Eugene Brown.
David Cassels for Mr. Brown. And Judge, I would ask the court to consider bond.
Okay. This is Kenneth Eugene Brown, sexual battery, victim over the age of 16 but under the age of 18. The court finds probable cause.
Judge, can I have a moment to locate the probable cause affidavit?
Counsel, I'm sorry, I can't hear you.
I
You're talking
apologize. Can I have a moment to locate the probable cause affidavit since we're calling it out of turn? What page is it on?
20. Brown, Kenneth.
This when they were dating, she stayed over. He was to do him, quote, a favor of taking him somewhere the following morning. And according to the allegation, he forced her to have sex in the middle of the night.
Thank you.
Anything?
No, Judge, I would just I'm still trying to locate what bond is the defense seeking?
His name is Kenneth Brown. It's about 3/4 of the way down.
Found it. Judge, I'd be asking for a $15,000 bond based on the allegations within the probable cause affidavit.
I was gonna ask for 10, but at the court's discretion.
Okay. State, you're asking for what?
$15,000 bond.
Okay.
I was gonna ask for 10, but at the court's discretion.
Okay. Court sets bond the amount of $10,000, no contact with the alleged victim. And have a good day.
Thank you, Judge. You too.
Giordani Charleston. On Charleston, we have a felony battery. It's a capious. The court sets bond the amount of $5,000, no contact with the alleged victim. What happened to the other charges, State, do you know?
I
There's
don't know.
allegations of theft, robbery.
The only one I have in front of me today is the,
I understand that.
Right.
But in the probable cause affidavit, they spell out,
I'm assuming the state only decided to file them.
thank you. Somebody had good information. Appreciate that. Okay. Serve
Judge
bond, set the
Forsythe
amount of
here.
$5,000, fine probable cause, no contact with the alleged victim.
Judge, he's got a job with UPS, and it's a felony battery. Could we lower the bond from 5,000?
Not at this time. Antonio Persia. Pre-shot. Okay, sir, you're charged with a violation of probation. No bond hold. You'll be detained going before the judge on the 4th at 9:40 a.m. Malcolm Lacey. Malcolm Lacey, you got an out-of-state hold out of the state of Georgia. If you don't have anything pending locally, you'll be taken before the judge for extradition proceedings this week. Have a good day, sir. Erica Harwell.
North Broward.
Medical reset, Your Honor.
Oh,
She's a medical reset.
Harwell's a medical reset?
Yes, sir.
Okay. Okay. Valerie Magliori.
North Broward.
present, Your Honor.
You're very, okay, you've got a misdemeanor capias, ma'am, for trespassing, $250 bond, fine probable cause. You want to plead no contest?
Yes, Your Honor, no contest, Your Honor.
Time served. Have a good day. Wave closed. Alexia Hudson.
Judge, could we get an OR on this? Is the first time DWLS?
This is a driver with a suspended driver's license. Court finds probable cause, and the court is going to ROR her. Ma'am, you need to get your license straightened out and appear in court. Don't miss court. Have a good day. Gamage. Janae Gamage.
Paul Ryan, Your Honor. Oh, excuse me.
Ms. Gamage, you're charged with possession of THC and a traffic violation. Bond set in the amount of $1,000. I find probable cause.
Cocaine.
Pretrial?
Cocaine.
Excuse me, one at a time. What is? We'll take whoever you. Okay. Pretrial release, ma'am. You need to have an evaluation and any counseling if required. Vernette Wilkins.
Medical reset.
Thank you. Okay. Deanna Cacade.
Okay. North Broward.
Okay, you've got robbery.
Judge,
And I've got a no bond on it. I have no probable cause affidavit. State, you got one?
I don't currently have one, but what I can do is I can print it out.
Okay.
She does have a pending robbery with a weapon, case number 184355 CF10A, pending in front of Judge Merrigan. The state filed.
This is in front of Merrigan.
I think it's the same case. This is a change of charge. This is not a new case.
I looked it up, it looks like it is a new case. I don't know.
Okay, the problem I have
I
is,
understand.
That's why there's no PC. It's because it's a change of charge.
I want
Okay.
to address the
Oh,
issue of Merrigan found probable cause, so I don't have an issue with probable cause. But it appears to be a bondable offense, and it's difficult for me to,
What I can tell Your Honor, it's a change of charge. Originally it came through as a grand theft. It's now being charged as a robbery. When probable cause was found originally, bond was set at $3,500. She has a no bond hold on a different case. I have no objection if we just keep the bond the same at $3,500.
I can print, that's fine, I can print out a copy of the probable cause affidavit if you wish to see it.
$3,500 bond. Probable cause. William McDonough. William McDonough, you've got a capias for $25, and,
Your Honor, this is a municipal ordinance case, and I believe.
I understand.
Oh, but just so you know, usually we have a representative from the McLaurin's firm come in for some
we
of these. They told me they were running late. I don't know if they were going to come in this morning or not, so I don't know if you want to put these on hold or we just do them. I'm just letting Your Honor know.
He'd like to resolve it, Judge.
I would think so. Sir, you want to plead no contest?
Yes, Judge.
Time served.
Thank you, Judge.
Anthony Holland. Mr. Holland, you've got two capiases, $50 each, for a municipal ordinance violation and a trespass. Do you want to plead no contest?
I guess so. You know, guess. I don't know. You want time served?
Choice is yours, sir.
Do you want to get out of jail?
Yeah.
You want to plead no
Sir,
contest?
you can post $100 in bond, you can plead no contest, or you can wait to be taken before the judge.
Yeah.
Which one do you want to do?
No contest.
Time served. Have a good day. No return.
What was a misdemeanor?
Willie Morris. Mr. Morris, you got an open container violation. You want to plead no contest?
Yes, sir.
Okay, fine, probable cause, time served. Michael Mancini. What do you need to sign? I don't know. You guys hide these things. Thanks. Mr. Mancini, you have municipal ordinance violation by probable cause, $25 bond. You want to plead no contest? Counsel, you're appointed to represent him. You want to plead your client out?
Judge, yes, but could I just have one moment to speak to Mr. Mancini? Just one moment, please, Judge.
All right, I'll put it on recall.
Thank you.
All right, then we have Brandon Johnson. Mr. Johnson, you got a $1,000 bond on a possession of cannabis charge. You want to plead no contest?
Yes. Yes.
Withhold court cost and waive the court cost. Okay. Julio Monteo. We have two capiases, one for $50, one for $1,000. I will, okay. And one's for trespassing. You want to plead no contest?
Yes.
Yes, sir.
Time served, no return to the property.
Yes, sir. Yes, sir.
All right, then we have Zachary Davis.
He's in North Broward. that he would have liked to resolve as well.
He what?
He would have liked to resolve. I spoke to him this morning. He's in North Broward.
Okay, Mr. Davis, you have a loitering and prowling, $25 bond. You want to plead no contest?
Correct.
Court finds probable cause, time served. Have a good day.
You too, sir. Thank you.
Good. Mr. Christopher Briggs, I'm sorry. Christopher Briggs. Mr. Briggs, you're charged with exposure of sexual organs in public. The court sets bond the amount of $100, and then unnatural and lascivious act, $3,000 bond. Court finds probable cause, both counts, no contact with the alleged victim, no return to the premises. Frank Kramer.
He's out with the private attorney, Judge.
All right. Oh, Mr. McLawrence, yes. Then we have D.U. Marcellus.
Did you just call Kramer, Judge? Frank Kramer?
All right, Frank Kramer, you have 2 municipal ordinance violation, $25 bond. You want to plead no contest?
Yes, he does, Judge.
Time served.
Okay.
You're appointed to represent him.
Thank you, Judge. Judge,
Okay, then what about, do you have Michael Mancini?
he's here, Judge.
He want to plead no contest?
Yes, Judge, he is.
Time served.
For purposes of the record, Judge, I just want the record to reflect that I explained to him that I filed a motion to declare that statute unconstitutional. We're having a hearing on it in January, but he's indicated to me he doesn't want to go through with the hearing. He just wants to resolve his case here today.
Time served.
Thank you, Judge.
And then Jonathan Bazunga. You're charged with soliciting $1,000 bond. You want to plead no contest? Time served.
Yes, Judge.
Then we have Marcellus. You're charged with battery, $1,000 bond, no contact with the alleged victim. Have a good day, sir.
Probable cause on it?
Find probable cause, yeah. But I believe probable cause is already found.
Okay.
Brittany Merzik.
He's bonded, Judge.
We have Brian Merzik.
He bonded.
Bonded. Don Lee Skinner. Mr. Skinner, you're charged with a misdemeanor. You got a capias by Judge Carpenter, $500. Do you want to plead no contest?
No contest.
Time served. Gerald Pugh.
Yes, sir, Your Honor.
You have two capiases of $500 each, and then you have 2 writs of arrest, $310 on one and $300 on the other. The writs of arrest were issued by Circuit Court Judge Dale Cohen. Now, if you want to plead no contest on count one, we can dispose of that. The court will ROR him on count two. Okay? But the writ of arrest, you're gonna have to deal with Judge Cohen with. You're either gonna have to pay the money or go back before him. Now, if you want to plead no contest on count one,
Yes, sir, I plead no contest, sir.
okay, then that's a withhold.
Time, sir.
Okay, yes.
All right, thank you, sir.
Judge, there was a count two, the DWLS?
The, I ROR'd him on that.
Oh, okay. You gotta go to court on this one.
Jacob, I don't have a court date. Jacob Dumkowski,
He's here in the main jail, Judge.
okay, appoint Mr. McLawrence. You want to plead no contest?
Yes, sir.
Time served.
Thank you, Judge.
Sean Young,
No problem, Your Honor.
Sean Young, you're charged with possession of drug paraphernalia, resisting a police officer without violence, trespassing, and trespassing. I find probable cause all counts. You've got $425 in bond. You want to plead no contest?
Yes.
Time served, no return to those properties. Michael Soprano. Okay, you're charged, sir, with DUI, $1,000 bond, DUI, $500 bond. You have $1,500 in bond. Court finds probable cause. Can you bond out on the $1,500?
No, Judge, he's asking for pretrial.
What was that?
He's looking for pretrial release, Judge. You can't post bond.
Okay. We'll send him to pretrial release, special condition of pretrial, no alcohol or intoxicants, and, yep. Have a good day, sir.
Thank you, Judge.
Cecil Burton.
No problem, Your Honor.
Mr. Burton, you're charged with possession of cannabis, then possession of cocaine, a violation of probation. I find probable cause all counts. You got 1,000 on the cocaine, on the violation of probation. It's a no bond hold. You'll be taken before the judge on the 4th. Have a good day. Michael Denston.
Judge, did you set a bond on count one for Mr. Burton?
No bond was required.
Okay.
Can I make how much? Yes. Okay.
Okay, Mr. Denston, you've got a resisting. It's an ad charge, so, and there's no bond required on it. So I don't think you want to do anything with it. It's a hold for magistrates? Okay, but it's a count 5 on a multiple count.
Yes.
Okay, bond is set, the court's gonna ROR him on it. Okay?
Did you find probable cause?
Yes, I found probable cause. The problem I have is I can't do anything with it because it's attached to four
Right.
other charges.
Right.
You understand?
Yes, Judge.
Have a good day. Joseph Knoll. You're charged with a violation of probation. I find probable cause, no bond. You'll go before Judge McCarthy on the 4th. DeAndre Coleman. You're charged with a violation of probation, no bond hold. Court finds probable cause. you'll go before Judge Bailey on the 4th. Matthew Estewell. Mr. Estewell, you're charged with aggravated battery with a deadly weapon. The court finds probable cause. Court sets bond the amount of $1,500. No contact with the alleged victim. Leroy Williams. You're charged with possession of, unlawful possession of an ID of another, $1,000 bond, fraud, misrepresentation of personal ID, $3,500 bond. Court sets total bond $4,500. Pre-trial? I can't hear you.
Whoever you refer.
Okay. Sir, do you want to go to pre-trial?
Yes, Judge.
Pre-trial release it is.
Probable cause on both counts?
What's that?
Probable cause on both counts?
Yeah, I found.
Okay, thank you.
Marino Lazo.
I believe we're going to need a Spanish interpreter, Your Honor. Also, we'll waive a formal reading.
And Judge, this is a PBL.
You're waiving the formal reading?
Buenos
Yes,
días,
Your
señor. El señor abogado aquí, el señor abogado defensor aquí presente le dice al señor juez que abandonan el derecho a que le lean las acusaciones formales.
Okay, on counts 1 and 2, it's a no bond hold. The court finds probable cause. Then on counts 3, 4, and 5, I believe those are bondable offenses.
Judge, I'd be asking that you find proof evident presumption great.
Señor, el señor juez habla para las acusaciones 1 y 2, no puede pagar fianza para salir en libertad y haya motivo fundado para detenerlo. Para las acusaciones 3, 4 y 5, el señor juez dice que estas acusaciones se puede pagar fianza para salir en libertad, pero la fiscal le pide al señor juez que por favor halle que la prueba es evidente y la presunción de gran envergadura. Thank you.
Okay. My understanding is that on count 4, is that a no bond? And then counts 3 and 5, bonds are required to be set?
So on 1 and 2, there are no bond. 3 and 4.
4 indicates
4 is saying hold for magistrate.
it's, okay, the way it's reading on mine says no bond, but that's okay.
Wait, sorry, I apologize. 3 says hold for magistrate. 4 says no bond, and 5 is hold for magistrate.
Correct.
La señora fiscal habla en cuanto a las acusaciones. Las acusaciones 1 y 2 no puede pagar fianza para salir en libertad. Las acusaciones 3 y 5 se le requiere al señor juez que imponga una fianza. Para la cuarta acusación no puede pagar fianza para salir en libertad.
Defense, you indicated you were waiving the reading.
Correct.
Are you opposing the no bond holds?
Your Honor just has to find proof evident presumption grade as to counts 1, 3, and 4 if you're going to hold them no bond.
That's what I was making clear that you weren't agreeing to it at this time. You were just waiving the reading.
Correct.
Okay, just wanted to clarify the record.
El señor
Okay, the
juez
court at this time, upon review of the probable cause affidavit, finds the proof evident, the presumption great as to counts 1, 2, 3, 4, and 5. The court has no bond holds on counts 1, 2, and 4. The court sets bond in the amount of $5,000 on counts 3 and 5. There'll be no contact with the alleged victim, and the court points the guardian ad litem for the minor child.
Your Honor, say a bond of 5,000 for charges 3 and 5?
5,000 on
Yes, Your Honor.
count 3 and counts 5.
Yes, Your Honor. Thank you. Señor, el señor juez habla. Después de haber revisado la declaración escrita juramentada, hallo que la prueba es evidente, la presunción de gran envergadura para las acusaciones 1, 2, 3, 4 y 5. Lo mantiene bajo custodia sin que usted pueda pagar fianza para salir en libertad para las acusaciones 1, 2 y 4. Le impongo una fianza de $5,000 para las acusaciones 3 y 5. Y usted no puede tener contacto o comunicación con la supuesta víctima. Your Honor, I'm sorry, the interpreter was left at no contact with the alleged victim. And then the fourth part, Your Honor.
Last part was that he was appointing the guardian ad litem to the minor
Yes,
child.
thank you so much. Y el señor pues ordena que se le asigne una tutora para el caso de los niños.
Your Honor, we're going to invoke Mr. Moreno's right to silence.
Y el señor abogado defensor aquí presente le dice al señor juez que invocan el derecho que usted tiene a permanecer callado.
Sir, your attorney has invoked your right to counsel. That means that you're not to speak to anyone about the case unless your attorney is present. And that includes on telephones, in any other way. You're not to discuss the matter with anyone. Have a good day, sir. Daryl Austin.
Señor, el señor abogado defensor aquí presente. I'm sorry, counsel, señor, escuche por favor. Señor, no se vaya. El señor abogado defensor aquí presente le ha dicho al señor juez que, el señor juez dice que su abogado ha invocado el derecho a que usted permanezca callado, que a usted le han asignado un abogado defensor y al menos que ese abogado esté con usted presente, usted usted tiene derecho a no hablar con nadie de su caso, ni por teléfono, ni de ninguna otra manera. Gracias.
Thank you. Daryl Augustin, I'm sorry. You're charged, sir, with, you got a felony violation of probation, no bond hold. You'll be going for Judge Bailey on the 4th.
All right.
Then we have
I didn't pick up no charge.
Dadron Lassiter. Mr. Lassiter, you got grand theft. That's your $1,000 bond. I find probable cause. You don't need bonds on the other charges. Pretrial release. Okay, sir, do you want to post a $1,000 bond? Can you post it?
Yes, Judge.
He can?
Yes.
Okay. No pretrial release then. Anderson.
He bonded, Judge.
Do we have Anderson and where's Anderson?
Bonded. Anderson bonded.
Bonded, thank you. Allison Braham. You're charged with retail theft, $3,500 bond. Can you make the bond?
No, sir. I was supposed to pre-trial.
Pre-trial, will you take them?
Whoever you require.
Excuse me?
Whoever you require.
You got them. Pre-trial release. Jarvis Harper. Court finds probable cause on that. Mr. Harper, you're charged with DUI, $500 bond, DUI, $1,000 bond, and introducing contraband at detention facility, $1,000 bond. I find probable cause all counts. Total bond is $2,500. Can you make the bond?
No.
All right, pretrial? You got it. Pretrial release, no special conditions, no alcohol or other intoxicants. Worth Behan.
B-Man. No fraud, Your Honor.
For count 2, his probation was revoked in January 26, 2018, and he was sent to prison. So the parole hold is valid, but I don't see that he was on probation.
Okay. All right, Mr. Behan, you have a battery. I find probable cause, bond is set in the amount of $1,000. You got a violation of probation. I find no probable cause. On the violation of parole, I find probable cause, no bond hold. You'll be detained on dealing with the battery charge, and you have the detention based upon the parole violation, and you'll be detained going for the parole officer. Thank you, sir.
Thank you.
Mark Whipple. Mr. Whipple, you're charged with driving with a suspended driver's license, $750 bond. Court finds probable cause. Court RORs Mr. Whipple. And Mr. Whipple, you need to get your license and appear in court. But whatever you do, make sure you appear in court, or there'll be a much higher bond the next time. Cuevas Aitken. Mr. Aiken, you're charged with possession of cocaine, $1,000 bond. Then you've got a capious misdemeanor, $500 bond. Then you have robbery with a weapon, no bond. Then you have aggravated assault with intent to commit a felony, aggravated assault with intent to commit a felony, aggravated assault, intent to commit a felony. Both on all three of those, bond are $7,500 each. Okay.
And Your Honor, when it comes to count 3, it's actually the counts 3 through 6. Those are all an out of custody warrant. They're an arrest warrant. If he's going to be held no bond on count 3, the charge, I know Your Honor said robbery with a weapon. That's actually a bondable offense, but I believe the capious is actually for a robbery firearm. In either case, if Your Honor is going to hold him no bond on that, you would have to find proof and or presumption great. I've reviewed the affidavit in the case, and I don't know if Your Honor's seen that yet before I make an argument about it. Have you?
Go ahead. I've already read it.
Okay, I just wanted to make sure, I just didn't want to talk and then you were going to read it.
I mean, this is the one
that the allegations are at a store, and then
he went out to the car, supposedly retrieved the revolver, and
I corrected count 3 and it has the paperwork. It should be firearm.
okay. Now, I believe, Your Honor, this is that allegedly as he was leaving the store, that the allegation is that he lifted a pant leg and that they saw something in the sock. Not that there was something that I don't believe the allegation is that he went to a car, came back, and brandished anything. Is that he was leaving, he lifted the pant leg. And so when he was picked up, there was no weapon found on him. This happened before the date. I don't know if that rises to proof and or presumption grade.
Date?
Judge, I would just be objecting to the defense arguing the facts as to.
Well, then how else do I make a decision as to presumption, proof evident presumption great?
You base it solely on the information that you're provided within the affidavit to arrest. And whether the affidavit to arrest, the information within that document rises to the level that the court would consider that it's proof evident presumption great.
Well, I believe that he has a right to make argument that it does not.
I don't disagree that he could use the affidavit, but the affidavit is that the allegation is that a pant leg was lifted and the loss prevention officer saw something. The loss prevention officer believed it was a firearm. I believe in a PC that they say it was the loss prevention officer believed.
Well, there's a little more than that, counsel, because a Mr. Frazier, who was familiar with weapons, clearly identified it as a small caliber revolver.
Again, I don't know how close they were to it.
Well,
And
that's,
it's a
but
split second.
I understand that. This is a magistrate or first appearance hearing. The court does find the proof evident presumption great. There is a no bond hold, and let me try to see. Oh, we don't have. Okay, sir. You'll be detained going before the judge to whom the case is assigned. Charles Laporta.
No problem, Your Honor. Yes, sir.
Mr. Laporta, you have a possession of cocaine, $1,000 bond. Can you make the bond?
No, Your Honor.
All right, do you want to go to pretrial release?
Yes, Your Honor.
If you do, you have to have an evaluation and follow-up treatment if recommended. You understand?
Yes, Your Honor.
Okay, pretrial release. Devon Andrews, court finds probable cause. Devon Andrews, you're charged with grand theft auto, $1,000 bond, I find probable cause. You have a possession of cannabis charge, and then you have 2 violations of probation, no bond hold. You'll be detained going before the judge on the no bond hold on the 4th of December. You have your hearing. Have a good day, sir. Donnie Warren.
No problem. Yes, sir, Your
Okay. Donnie Warren, you're
Yes, sir.
charged with, you got a court order, no bond hold. And that's by Judge Shearer. Do we have anything?
The information I have that it was a change of charge from possession of PVP to possession of substituted cathinones.
Bond was originally set at $1,000.
Then how's it a whole no bond hold?
I believe it was no bond for him to be brought here.
Okay.
Because it's a change of.
Actually, Your Honor, the bond was revoked back in 2018. It was changed, the charge was changed, but the bond was revoked. So I don't
What was
know
the
why
bond
it
revoked for?
I think because he had direct charges and they revoked the bond in magistrate. And then it was COC after the fact. But he's being held no bond on that entire case.
All right. Bond is set in the amount of $1,000. Court finds probable cause. All right. Michael David Maxwell.
County, Your Honor.
Mr. Maxwell, you've got battery on a person over 65 years. I have a no bond hold. I have no PC sheet.
Again, Your Honor, this is a change of charge. When he initially came through, it was a first-degree aggravated battery on someone 65 or older. It's now been downfiled to third-degree felony, just battery on 65 or older, so it's a third-degree felony. Originally, bond was set at $25,000 when it was a first-degree felony. He's being held no bond on a separate count, not before us today. I'm asking for a $1,000 bond since it's a downfile.
State? He's got a no bond hold on
Right,
it.
he's being held on the carjacking, no bond, that's, the $1,000 bond is fine.
Okay, $1,000 bond. Probable cause found. Have a good day, sir. All right, then we have Ricky Nelson Capron.
Nassau County, Your Honor.
All right, we have burglary, no bond hold, and burglary unoccupied, convenient, unarmed.
Judge, both of these counts are PBLs. The state would be asking that you find proof evident presumption great.
I don't have any probable cause affidavit, I can't.
Okay.
I haven't seen anything.
I have it right here.
Besides this, counsel, they're burglary. of a structure
Armed.
and then burglary of a conveyance. One says armed, one says unarmed. I don't know that we can rely on the armed in the first one if he wasn't armed in the second one.
I would just be asking, because the count one is armed, I went through, I can give you a copy
No,
of
but I
it.
don't have anything.
I can give you a copy of the probable cause
Okay, well,
affidavit.
that'll help.
Sure.
Let me see it. Thank you. Okay.
There aren't, I can tell you right now, that there aren't allegations within the probable cause affidavit that the defendant was armed. I read a supplemental report, that indicated.
Well, I need to see where he's armed. Let me just
Sure.
read this.
I will print 2 copies out.
Okay. There's no arming. Now, let me just say, wait a minute, another page.
Because it's not within the probable cause affidavit, I would just ask for 48 hours to perfect. Actually, there is a supplemental report with the armed, hold on.
Well, I've got the supplemental. You're talking about the Ed Moore Chevrolet dealership?
Yes, but there is, I'm looking.
The only thing they've got is a possession of burglary tools on that one. I mean, in other words, he has a screwdriver or something.
But they did recover a firearm.
I have nothing
I'm looking for it right
on
now.
the file. Here, counsel, you want to review these while I'm waiting to hear about the. Withdraw. Thank you.
Judge, I can't find it right now. I saw it and I can't locate it. I would just ask for, time to perfect as to the armed.
Your Honor, my argument would be, this is something that's been open for a while. This is a filed case. He would be prejudiced today if we do hold him.
Well, the
no bond on
problem
it.
I have is that I have two rather complete reports, and I see nothing in them referencing a firearm.
I can find it. It's just the report is 48 pages long, so I'm going through it.
Then, counsel, the problem is, I have to have something to make a decision on, and if it's available,
It is available.
then let's,
Okay.
okay, we're gonna put this on recall. Then we have Randy LaPenta. Mr. LaPenta, you have a violation of felony probation, no bond hold. You'll be taken before Judge Garcia Wood on the 4th of December.
Tuesday.
Okay, then Ross Fisher. You're charged with forged or altered promissory note, grand theft, and fraud. I find probable cause, all counts, bond is set in the amount of $3,000 total. Can you make the bond, sir?
No, sir.
Pretrial release? You'll take them. You'll be on pretrial release, sir. Find probable cause, all counts.
Judge, I found the report on, Caprone. I'm gonna print it out now.
Okay, we're back on Ricky Nelson Capron.
Graham have the firearm found on ABET as evidence and turn it over to CCPD property. There was a co-defendant.
Let me see, let me just see where that, okay. Okay. That was found on
The co-defendant.
the co-defendant.
Who he was with in the vehicle when they performed these acts. So I think it was originally charged as unarmed, but when they recovered.
When was he arrested?
The top of that second page in that stack.
Right, no, I understand that's where it's.
So the, just for clarification, Mr. co-defendant is neither Abed.
What was that?
Mr. Caprone's co-defendant is Nader Abed.
Mike, you're on.
Okay. All right, so state, your point is that there was a weapon found somewhere in reference to the co-defendant, correct?
Yes, who was working in concert with the defendant, which is why it was changed originally from the unoccupied conveyance unarmed to the burglary dwelling structure or conveyance armed.
Okay. Counsel?
Your Honor, so a couple issues with Mr. Caprone. Regardless of what we do here today, he's going to be held on no bond. The counts before us today, count 1s and count 8, are just, I believe, 2 out of the total 8 counts he's facing. He's being held no bond on counts 5 and count 6, regardless of what happens here today. Reading the supplement, the allegations within the supplement are that the co-defendant had a weapon in his pocket. The allegations seem to stem from stealing rims from a car, and so that there was no one necessarily, this wasn't like an armed robbery. And so I would ask Your Honor to use your discretion and set bond as to count 1. He is entitled to bond on count 8. Count 8 is being charged as unarmed.
Dave? State, anything else?
No, nothing else, Your Honor.
Okay, on count 1 and count 2, the court finds probable cause. On count 1, bond is set in the amount of $25,000. On count 2, the bond is set in the amount of $10,000. There's already no bond holds. Okay,
And
thank you
Judge,
very much, sir.
And Judge, on count 1, you're not finding proof evident presumption?
I'm
Great.
not.
Okay.
Okay, thank you very much. I believe that concludes the docket. Good job by everybody.